Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching and thank you for listening. I'm going to talk a little bit about day 64 of the Mass Casualty Commission proceedings. As you can tell, I'm not in my usual location. Just like the last video, I'm over in St. John's, Newfoundland, playing in the fast pitch national championships. So I've been trying to follow along with things. And last night, I guess it was getting close to 11 o'clock coming back from the ball field, I was checking through Twitter and I saw Heidi Petroshik's tweets about this decision that came out from the Mass Casualty Commission commissioners yesterday, Friday, late Friday before a long weekend, as has become a real pattern with the Mass Casualty Commission, releasing things on a Friday, particularly before long weekends. And anyway, I've gone through that before, so I won't dwell on it, but that is certainly anything that comes out at this time of a week in a news cycle is usually going to be bad news for the person releasing the news, or something controversial that they're hoping few people see, fewer people give it their attention. So I certainly saw it, and it's been brought to my attention by a number of others as well. And so wanted to talk about that. And what it is the decision that this Constable Greg Wiley, who's a real key witness, went to visit Gabriel Wortman, the perpetrator, 16 times over the course of a few years, seemingly became friends with the man. And here's an RCMP officer who's had an inside look at this man's life and is set to testify Tuesday when we come back after the Labor Day weekend. But the Mass Casualty Commission has taken the decision that Constable Wiley's testimony cannot be disseminated, it cannot be used. His audio, the video of it, can't be published by any media organization. And the commissioners have actually gone to the additional step of noting that anybody who does violate that order is liable to be prosecuted under Section 127 of the Criminal Code. So I want to talk about some of this. So the first thing is, so they've made the request under Rule 43, which is the rule that of their commission's rules of procedure, which allows for special arrangements or accommodations for witnesses. And we've seen this before, always from the perspective of the RCMP, a little bit with Lisa Banfield, but the problem, okay, so one of the things is, so an application is made for accommodations. Medical evidence or personal evidence of the individual is provided to the commissioners, and then they make their decision. There's some input from the participants, but none of that input, none of the briefs, none of the reasoning, even a redacted version of that, none of that is made public. So we really have no clear sense of what the reasons may have been, just some vague allusion to medical reasons. So that could be anything from anxiety to, I don't know what. It's some mental health considerations. It's a little different than the previous issues that we've heard with the various staff sergeants who requested accommodations, some of which were granted, most of which were granted. In those cases, though, we were able to watch their testimony, such as it was, and media could still broadcast it. In this case, people can listen in. It's going to be done over Zoom. A transcript will be posted of it after the fact, but nobody can use the video. So it's not clear, what the reason might be. If Constable, there's something about his appearance that cannot be made public. If there's an issue, he can't be an undercover officer at this stage. He's such a well-known name, presumably. But anyway, whatever the reason is, we still don't know it. It's got to be a health reason that's granted. Now, this is all very difficult to accept because in every case so far where accommodation requests have been made, have been requested and granted, the witnesses have testified, and in all cases it appears that the accommodations weren't really needed. And these are police officers in most cases that are used to testifying regularly and without accommodations. And we've seen everybody else has gotten up on the stand and testified and answered difficult questions. This is a key witness whose testimony is very important. And there's so there's really no trust in the commissioner's judgment at this point when it comes to making these accommodations. In fact, here's another element of this, and may have flown under the radar. When I read the decision, so everybody has input. I think the federal government made the request through the Commission Council, and then participants have the chance to have their input. Well, the Commission Council, who is like the Crown Prosecutor, is supposed to be thinking about the public interest in all this. Their recommendation to the commissioners was that Constable Wiley only testify by affidavit, by written affidavit, no questioning whatsoever. Very curious that the Commission Council would take that stance, but then the commissioners didn't accept that. They said, well, he'll testify, but under these conditions. So questions, my first set of questions would be for Commission Council is, how do you think that one of the most important witnesses can only testify by affidavit, and that is somehow acceptable? That is stretching the trauma-informed mandate beyond anything that it can hold. Okay, so it's within the commissioner's ability to make this ruling. The testimony will be webcast. It's a weird way they worded it. It says that his testimony will not be webcast and a transcript be posted on the website. I think they mean but a transcript will be posted on the website. I think from the wording, the way it's worded, we will see a transcript of this after the fact and be able to check in on it. I mean, I'll be watching. I made the request. I emailed the person at the commission that is supposed to provide the Zoom link, so I'll be watching. We'll see if there's any reason for this accommodation. Okay, so as I said, the commissioners went to the additional step of saying anybody who violates this can be prosecuted under Section 127 of the Criminal Code. Okay, what is that? 127 of the Criminal Code says that everyone who, without lawful excuse, disobeys a lawful order made by a court of justice or person or body of persons authorized by any act to make or give the order. All right. So there's a few sections that sounds like one thing, but there's a number of elements of that. So first one is a person without lawful excuse. I'm going to come back to that. Disobeys a lawful order made by a court of justice or person or persons authorized. Okay, the Mass Casualty Commission is not a court of justice, but they are a person or body of persons authorized by any act to make or give an order. The Public Inquiries Act of Nova Scotia authorizes the commissioners to make the equivalent of court orders, or what would count as a court order in this case. All right, so a lawful order is an order authorized under an act, which they would be. Disobeying it without a lawful excuse. So I thought about that. I was like, well, what about the public interest in the truth, court proceedings? What about, free speech and all of that? Could a broadcasting organization just say, well, we're going to broadcast this anyway because we feel that there's a public interest in it and it's a free speech issue, and that is our lawful excuse? Court decisions I've scanned through do not support that. The steps that it seems a media organization would have to take in order to broadcast any of the images of Constable Wiley would be a court application fighting this ban, saying, okay, well, this order that was made, we want to apply for an exception, and they would have to give the reasons for doing so. And then I think in the first case, they'd have to make the application to the commissioners. The commissioners, if they rejected it, then the applicant could apply for judicial review to have that decision reviewed by a judge of the Supreme Court. That's all fine, except that would take months to do at best, and that's just not going to happen in any practical sense. So there's not an easy way to get around this, and it's not the case, I think, that although many people would support a media organization if they did this, it doesn't seem like the judicial system would support that support. So we're going to have to live with this terrible decision, but it really, further undermines the legitimacy of the Mass Casualty Commission. I mean, making decisions like this with the most key of witnesses is really cuts to the core of what they've been doing, and really it just echoes earlier decisions where their credibility has been undermined, particularly in the lawyers working for the commission and the commissioners themselves. It's quite amazing. I mean, there's an unusual thing too. I mean, without explaining what it is particular about broadcasting Constable Wiley's image that is contrary to his mental health in some way. What could possibly be going on there? So, unfortunately, we don't get that information. I think it's incumbent upon the Mass Casualty Commission lawyers, when they start questioning Constable Wiley, to go through some of that, and so we'll see if they do so. But this is a really bad decision made on a late Friday to hopefully that would fly under the radar. Nobody's going to care about it. I think that's a miscalculation on the part of the commissioners. I think many people are concerned about this, and when people start paying attention again to this as the September rolls around, we're past the Labor Day weekend, then I think the public is going to be very upset. I think the participants are going to be very upset. I wouldn't be surprised if there's discussion at least of a further temporary boycott of the proceedings on this basis. So we'll see what happens. That was what I wanted to cover. It was pretty startling but not surprising decision by the commissioners to allow Constable Wiley to get off the hook a little bit with this. I mean, he has many questions to answer. So we'll see what happens on Tuesday when he does testify. Like I said, I'll certainly be watching the proceedings, and I'll describe it to you as best I can without certainly taking any pictures or disseminating his words in violation of the order. Okay, so that's it for today. Update from St. John's. The Nova Scotia Mastodons team, they're in first place in their division and playing in the playoffs today. We finished third in the Masters division, the other Nova Scotia team, and so we're playing at 4 today. If we win that, we're guaranteed a medal and hopefully more. Okay, so we'll be following along with the rest of that, and hope everybody has a good Labor Day weekend, and we'll see you next time.